Ladies and gentlemen, so we are back to the conference and to the last panel but one. So we have a great responsibility. We have to be interesting. We have to be on time. And so in order to be on time, I'll follow up on the steps of Henry Gabriel. So this is the message. Wow. For the interesting part, well, we have an incredible group of panelists here, so they will take care of that. We're very fortunate. And the second good ingredient, I think, is the topic, because the topic is UPICC in national courts, to say it shortly. And this is actually a growing phenomenon, as you know. It's something that it's gaining in interest and has many different facets, so it can be treated in many different ways. And we can see the case law from a variety of countries around the world, national courts, referring one way or the other to the UNIDROIT principles, and we'll see what are the ways and what we can learn for the future of UNIDROIT and its implementation. And this reaches to more than 40 different countries and also to the highest courts. So it's actually a variety of different courts involved. So we have two main topics that will be addressed here regarding UPICC and national courts. The first will be the UNIDROIT principles as proper law of the contract or applicable law, even when we talk about decisions of national courts, domestic courts. And this topic has already been discussed or at least mentioned in previous panels. Also, the other topic has already been mentioned, and in particular in the latest panel by Isa Friedrichs. So the principles used by domestic courts to interpret or to supplement domestic law, the domestic law which is the applicable law to the contract. And as we all know, this particular way to use the UNIDROIT principles, to refer to the UNIDROIT principles in a variety of different ways, was not initially expressly envisaged by the drafters of the UNIDROIT principles. If you look at the preamble in 1994, but it became so important in practice that then this was an element that was added to the preamble. And when we see the decisions collected in UNILEX, we see that more than half of those decisions are actually dealing with this particular way of referring to and using the UNIDROIT principles. Of course, decisions of domestic courts are usually much easier to find and to publish, so that might also be one reasons for that. So we will start then with the first topic, and the UNIDROIT principles as applicable law in domestic courts. And the first speaker will be Maria Ignacia Vial Undurraga, who is here. And you have a short bio of all the panelists in your brochure. But let me say that she's a professor of private international law at the Universidad de Los Andes and Pontificia Università Católica in Santiago de Chile. And She is a new member of our governing council. Maria Ignacia, you have the floor. Thank you. 15 minutes. Yes. You have seen. Thank you.
To fall asleep because if the speaker falls asleep, that would be terrible. But anyway, I will try to show you something which I find interesting, which is the use of the UPICC as the proper law of the possibility of using the UPICC as the proper law of the contract in Latin America. And I will show you how this possibility has come to a reality in Latin America. First, which was the one? This one? Okay. Well, the first thing I want to tell you is that there is a distinctive and increasing trend in recent Latin American domestic conflict laws to enable the parties to choose the UPICC as the proper law of the contract beyond arbitration proceedings, which this is the distinctive trend, you know? And the consequences of this trend is that first, Latin American laws guarantees the UPICC's enforceability within Latin America. And the other good thing is that the UPICC might provide fair rules not included in domestic contract laws. Yesterday, they were commenting that undeveloped laws, well, I don't want to say that Latin American laws are undeveloped, but less developed laws might benefit from using the UPICC. And I think this is the case. And then the use of the UPICC might contribute, which I think is quite interesting, to a de facto harmonization of contract laws in Latin America. This is my idea, at least. Well, I'm going there, sorry. I'm learning, yeah. So there are two historical landmarks that can explain this development in Latin America conflict laws. First, the drafting process of the Inter-American Convention on the Law Applicable to International Contracts, which is called the Mexico Convention in 1994, under the umbrella of the Organization of American States. And then the drafting of the Hague Principles on Choice of Law in International Commercial Contracts in 2015. First, let's go to the preparatory works for the Mexico Convention 1994. And these preparatory works, well, they began with an initial draft, which was prepared by the Inter-American Juridical Committee, but this first draft didn't mention anything about rules of law. But then, when this draft was discussed in a Tucson meeting of experts in November 1993 at the National Law Center for the Inter-American Free Trade, the NATLAW, then the discussion about introducing rules of law to govern international contracts began. Let's see, you see it's November 1993, the UPICCs were being drafted, so these ideas were in the air. So there, the director of the NATLAW, Boris Kosolchik, who's there, said that the principles of international commercial law should be incorporated as the main source of the parties' obligation. And the Venezuelan professor, Gonzalo Parra Aranguren, there, said that the convention should state that the principles of the lex mercatoria ought to be the principal binding source of supranational law for governing international contracts. So at that moment in Tucson, the experts agreed to introduce or to add to the first draft a new provision, which is now Article 10 of the Mexican Convention, that spoke, or at least mentioned, the rules of law. So say, in addition to the provisions in the foregoing articles, the guidelines, customs, and principles of international commercial law, as well as commercial usage and practices generally accepted, shall apply in order to discharge the requirements of justice and equity in the particular case. The provision is not so clear, but we are going to see how it has been construed. Sorry, I'm always making the same mistake. So then this draft was discussed in an Inter-American conference in 1994 in Mexico, and there the American delegate, Professor Fred Junger, suggested that, again, that the international contracts should be governed by principles, international principles recognized by international organizations. And since there was a bit of discussion about it, he says, in the case of absence of, first of all, the contract shall be governed by the law chosen by the parties, but in the case of absence of choice of law by the parties, he said the contract should be governed by the general principles of international commercial law ascertained by international organizations. And he backed his opinion, quoting a very famous Uruguayan author, who is Quintín Alfonsín, who had declared previously that no domestic law is perfectly suited to govern an extra-national legal relationship. Thus, the adequate private law needs to be extra-national. Well, Professor then Junger suggested the convenience of applying the recently approved UPICC 1994 as the proper law of international contracts. At the time, this was very revolutionary, I would say. Then his proposal was hotly debated within the drafting commission, and some countries opposed him, and then the Brazilian delegate proposed a compromise wording and ordering the court, in the absence of choice of law by the parties, to take into account the principles of international commercial law recognized by international organizations. And then it was agreed that the term international organizations should be understood as referring to any international organization, governmental or not, that codifies rules of lex mercatoria, for instance, UNIDROIT. Well, so here we have the Mexico Convention and the chapters, the articles on determination of the applicable law. The first great thing was that at least they proposed the principle of party autonomy to be adopted by all Latin American countries. So the contract shall be governed by the law chosen by the parties. Article 9, if the parties have not selected the applicable law, this election proves ineffective, then the courts will have to ascertain the law, but they should take into account the general principles of international commercial law recognized by international organizations. And then there's another article, Article 10, that says, in addition to the provisions in the foregoing articles, the guidelines, customs, and principles of international commercial law, as well as commercial usage and practices generally accepted, shall apply in order to discharge the requirements of justice and equity in the particular case. So if we see here, we have the UPICC are described in the first and Article 9, and then here in Article 10, we have the lex mercatoria. Well, the question here is, did the Mexico Convention 1994 permit the parties to choose a non-state law to govern an international contract? That's the main question here, because the wording of the provisions are not as clear as we would like them to be. So there's no consensus amongst authors. There's a great number of authors and very authorized authors who were, some of them were present in the conference where the convention was drafted. Professor Junger, Parra Aranguren, Arden Breton from Venezuela, Peter Nye, Australia, Perez Nieto, Mexico, and Sam Levin, who is the German expert in Latin American law. They all say that the Mexico Convention allows the parties to choose the UPIC as the proper law of the contract. And their reasoning is quite good. They say, if the convention assigns a fundamental role to international principle, then if the convention orders the courts to apply them in the absence of choice of law by the parties, even more so, it allows the parties to choose them to govern their international contract. That's why Sam Levin says that the convention allows the court to depart from its conflict rules when they do not point to a really connected law to the contract and to apply principles to govern the contract as its proper law. Then there's the group of people who say that the convention doesn't allow to choose the UPIC or the principles as governing law. Professor Antonio Boyano, Fernandez Arroyo, Herbert, Professor Landó, Santos Velandro, they have the negative answer, and they say that the principles are in the Mexico Convention are auxiliary tools for the court to determine the national law governing the contract or to supplement this law when needed. Hence, they say every international contract needs to be governed by a national substantive law. Well, but let's see what happens afterwards. The Mexico Convention was not really a very successful convention. It was enacted or is in force only in Mexico and Venezuela since 1995, but it has a very important radiation effect on all the Latin American conflict laws statutes that has been enacted afterwards, and even it has gone, well, you cannot see that, it has gone right to The Hague. Yeah, so what has happened? Venezuela, after the Mexico Convention, enacted its Private International Law Act that accepted the rules of law to govern a contract. The same did the Dominican Republic, directly influenced by the Mexico Convention, in 2014. Then Panama, Argentina, and though Argentina has a different approach, which comes from the Boyano doctrine of substantive autonomy, this power of the party to derogate from the mandatory rules of the substantive law applicable to the contract and to agree other principles or laws to govern a contract. That substantive autonomy is accepted in the Argentinian Civil and Commercial Code of 2014. And then we have the Hague Principles on Choice of Law in International Commercial Contracts. Well, I should not be speaking here about this because José Antonio Moreno was one of the principal authors of having the Mexico Convention been studied in The Hague. And then these principles influenced the Hague Principles. And it happened something funny because the Mexico Convention went to The Hague, but then it came back. It came back to Paraguay in 2015, who adopted the Paraguayan law in international, private international law that adopted the Hague Principles, and then in Uruguay in 2020, and also I want to mention the bill of the Chilean Private International Law Act of 2020 as well. So we have all these to say that my preliminary findings are that the Mexico Convention paved the way for the acceptance of party autonomy and choices of the lex mercatoria to govern international contracts in several Latin American national conflict laws. These national laws allows the parties to choose the UPIC as the proper law of an international contract. The Mexico Convention also influenced the Hague Principles of Choice of Law of 2015. And in the end, I have to say that the Mexico Convention has moved Latin American countries to embrace the principle of party autonomy with very few limits and to become pioneers in permitting the parties to choose transnational law and international principles as the governing law of contracts. Which are the advantages? Well, it ensures access to and enforceability of solutions that are not currently in Latin American domestic conflict laws. I want to give I want to give an example. Well, something happened, but anyway, I want to give an example of what happened in 2016 in Chile. There was a Dutch company, very well and prestigious, that bought 22,000 tons of salmon from a salmon farmer in Chile. That was to be delivered in 5 shipments between April and September of the year 2016. And we have a problem in Chile because we have a very harmful alga bloom that killed 85% of the salmon production of the year. Yeah. So what happens is that the first shipment was going to be delivered in Rotterdam in April of 2016, and the 8th of April, the producer, Marine Farm from Chile, informed the purchaser, the Dutch purchaser, that they were not going to be able to deliver the salmons because most of the salmons had died. Yeah? The bloom went from mid-February to all the month of March, and this the Chilean producer only informed on the 8th of April that they were not going to be able to fulfill their obligation of the contract. But at the same time, the Chilean producer informed that he could renegotiate the contract and buy to other producers who had salmons at the time, but at a higher price, which was not a huge difference. It was 7 euros 20 the kilo, and they say, well, we could charge you, if we buy to other producers and filleted the salmons, we could charge you 7 euro 50 the kilos. Well, the Dutch producer didn't accept this and filed in Chile for termination of the contract and damages, and at the same time bought replacement goods in Norway. So he bought but the Chilean producer said, well, I am not able now to send, but I could send them now, but at this higher price, but I can in next month, for instance, September and August and September, I can send it at the same price as before, we had agreed before. In the end, what happened, which was very bad for both parties, is that, well, the judge, quoting the Warsaw Convention, decided that the contract should be terminated with damages, but reduced the damages using the definition of reasonable notice, saying that the notice that the Chilean producer had given to the Dutch purchaser has been belated. So they were liable for damages. But at the same time, they say that the alligator is coming. So they the court ruled that the replacement purchase had been unreasonable because it was the price of the replacement purchase was 8 euros like 50. It's much more expensive than the price that the Chilean seller was asking for the renegotiated contract. So in the end, both parties lost a lot of money The Dutch buyer didn't receive all the damages, and and the Chilean was not able to prove force majeure. So if in this contract they had chosen the hardship clause of the UPICC, the solution would have been much better for both parties, for the Dutch company and for the Chilean company. That's why I'm thinking that the UPICC could be very useful for many international sales in Latin America. Thank you.
Thank you very much, Maria Ignacia, for this very interesting presentation and also the concrete example that you gave. I know that you had other things to say, but perhaps this will come in the discussion and in the paper afterwards. Now we would like to move to the second topic, which is the use of the UNIDROIT principles as a kind of background law for national courts. And therefore, I will give the floor first to Alejandro Garro, who, it's very well known at UNIDROIT as well, a professor of law and senior research scholar in the Parker School of Foreign and Comparative Law at Columbia Law School, and particularly relevant in this context, he participated very actively in the development of the UNIDROIT principles. So Alejandro has co-authored with Professor Moreno, with Jose, the general report at the International Academy of Comparative Law on this particular topic. And so I'm very glad to give you the floor for 15 minutes. Thank you.
Thank you very much. Thank you very much for the invitation. I will try, of course, to save myself from the alligator's threat. And I would, within this time, I would like to put in context what I was the assigned topic that I was given. And as Anna just anticipated, the topic of the use of the UNIDROIT principles as an applicable background law and applied by state courts and judges came out not only because it's subjects that have not been addressed yet among the many subjects that have been addressed, but also the fact that we had the privilege of, with Professor Moreno, of actually researching this issue in national reports that were filed years ago with the International Academy of Comparative Law, who was actually interested in the actual use of the principles. And one of those uses we were interested in came out, and the reports really showed it, and there were at least a couple of dozens of reports, if not more, that the use of the UNIDROIT principles as a sort of a restatement of the law of contracts came to be the most used of all. And that were not used only by international arbitrators, but as Professor Gama pointed out yesterday, very much used by state courts. So I think that if I put in context what we have been discussing up to now in this conference and the topic that I'm assigned, I'm not going to cover then those areas in which the UNIDROIT principles have been directly applicable, as either as a choice of law rule or as incorporated into the contract. Neither I'm going to be discussing about a very interesting issue about when the parties do not choose the law, whether or not the UNIDROIT principles can apply the role, because Christina Ramberg yesterday gave a very interesting explanation about how in the proof of the foreign contract law, the use of the UNIDROIT principle as a standard comparative basis played a very important role. What I'm going to be addressing is mostly the area of the issue of the interpretation and supplementation role that the UNIDROIT principles play in the situations where the uniform law has to be applied, or more apt to my discussion here is when the applicable law happens to be domestic law. And I think that's interesting. That should be compared among the 7 paragraphs of the preamble with the last one, which we already had the opportunity to hear a presentation here, just this panel that preceded mine, about how the UNIDROIT principles have been used as a model. I'm going to talk about the use of the UNIDROIT principles as a restatement, background law, jus comune, the idea that actually those principles represent general ideas on contract law. And we all know that that's not true, generally true, because it's not a replica or restatement of the law. We know that in many areas, the UNIDROIT principle is innovative because the drafters chose the better law rather than what they thought it was a better law rather than just simply going to the majority of legal systems. But that's one of the challenges that the application of the principles fortunately offer. Let me then go to the issue of the use of supplement as an interpretation tool or a supplemental tool. That means that with the UNIDROIT principles could be used not as a binding with a binding force at all because they play a subsidiary, a secondary role. But really, the fact that they play a relevant role is irrelevant for what I'm going to say, which is the enormous impact that the principles had, despite the fact that are not binding. And the best way to start the discussion is by just frankly bringing to your attention the role that the UNIDROIT principles play in the interpretation of other international conventions of uniform law. And this issue was also addressed yesterday morning. Very interesting that with reference to a tripartite guide that the three formulation agencies, the Hague Conference, the UNIDROIT and UNCITRAL put together to show how the UNIDROIT principles can play a very, very constructive role in actually interpreting and filling gaps in Hague rules, Hague-Visby rules, the areas of the law, such as the question of shipping contracts. Why not in insurance contracts, what we are seeing today in the panel of this morning, that it also plays that kind of a role. And now we're going to see that in international investment contracts, the UNIDROIT principles may also play a substantive role. So we see that that interpretation supplemental role in everything that relates to international cross-border transaction seems to be crucial because the other option, falling into domestic law, is not really ideal. And actually that issue was very much taken into account by the drafters of the CAG that very wisely in the second paragraph of Article 7 thought about the idea that the interpreter, the adjudicator, should not go to the choice of law rules or the private or international rules to apply domestic law. They should go to the general principles. Now, those general principles, and this is, of course, is controversial, whether or not the UNIDROIT principles can play a role in filling that gap, but some people have said no, just simply by the fact that the UNIDROIT principles were actually adopted after the CAG was adopted. I believe that that conception is a big mistake because I don't think that when the 7.2 points about the general principles under which this convention is based, obviously it's talking about not the UNIDROIT principles, but the convention CAG principles. But what better source to elaborate on what those general principles are than the UNIDROIT principles? Of course, I'm not talking about across the board every area. There are areas where issues that the CAG expressly left out, like Article 4 of the CSG Convention dealing with validity, and expressly, therefore, the UNIDROIT principles, Chapter 3 on validity will not be applicable. But what about in other areas where, like for instance, the question of interest rates, where the CAG left silent? Why not going to 7.4.9 subsection 2 that provides a very reasonable solution to the type of interest rate that could be applied. So I think that if we see that this is with caution, but we see that the UNIDROIT principles can play an important role in the unification, consistency, coherence in the interpretation of international instruments, and the CAG being the paradigmatic one, we now fall to the question of what about in domestic law? In principle, domestic law should be self-sufficient and should not need of any other additional law other than that itself to interpret or fill the gaps. But however, we all know that despite their self-sufficiency of all legal systems, if the transaction is international, the national commercial code or the national civil code or the national law, common law, may not have actually provided the best solution to the international transaction. And therefore, this is where the role of the UNIDROIT principles may play an important role to play. And actually, empirically, it has shown that it has been resorted to in various cases, and Professor Bonnell yesterday cited statistically the many cases involving many jurisdictions implicating lots of different types of disputes where you see that the UNIDROIT principles have played a role in the interpretation or supplementation of domestic law. Now, two things should be different, interpretation and supplementation. But let me say at the very beginning that I think that the UNIDROIT principles already has been used in the interpretation of domestic law. In those cases in which we saw this afternoon, it has been used as a source of a new civil code or an amendments to the civil code, and we go to jurisdictions as different as China in 2020, Argentina 2015, Lithuania, Estonia, and other Baltic countries. They have decided to rely not on the formula of the CIG, but sometimes in the better achieved formula of the basis of that the interpreter would the drop when they introduce that rule. An important point when the that is not one as nevertheless interpretation or well, I think that in many times because in cross-border transactions, linguistic others, currency, the codes provide no solution. The adjudicator be arbitrary legitimately. Sometimes may be used, and we have seen of 2004 decisions of the Court of Appeal state in Brazil, where a very give a solution just to the principles. Instance, interpretation would be the good thing to do. But if the dispute is really international, and if the dispute is B2B, commercial, there is a very good, strong point to use the UNIDROIT principles as a source. And that's why I think this is important. Perhaps we may also have to discriminate among different provisions. Open-ended provisions as Article 1.7 on the duty of good faith, which the CIG decided to bury in one provision dealing with interpretation of the convention, is a very delicate provision because it really, even though we have seen that courts and arbitrators may use it very repeatedly to moderate the harshness of a contract provision of an applicable domestic law. Well, this is what a very hotly debated issue within the CIG, and it was also hotly debated with the UNIDROIT principles drafting group at the time. But definitely is a true general principle that, unlike others, do not provide a readily given answer to cross-border issues that really call for some type of solution, not such as good faith, where every jurisdiction has its own modes of interpreting that rule. And we heard yesterday an English presenter telling about how the good faith does exist notion in English law, but is a functionary equivalent of what in the many common law decisions and statutory decisions English law recognizes as issues of fairness and honesty in fact. So I think that we have to be careful in when to use them for which purposes. But let's take the case, for instance, in the question of penalty clauses, where UNCITRAL has not been able to reach an agreement about whether or not the arbitrator or the judge may have the power to moderate the clauses, etc. Well, there is definitely a provision specifically in point 7.4.13 on agreed payments on the UNIDROIT principle that it seems to me give a very sensible and sensitive solution to that problem, and therefore has a legitimate claim to be used in the interpretation of domestic law when people are fighting about penalty clauses, liquidated damages, and such things of that type. Now, I would conclude with this saying that there are so many issues. I have one at this point pending decision on a difficult arbitration where the question was precisely related about not every breach of contract should lead to the termination of the contract. And the legal system doesn't seem to even have a specific provision saying that the breach must be material. I said, well, this is a cross-border transaction. The domestic legal system doesn't provide an issue here. We know that under 25 of CIG, the notion of fundamental principle, we have a concept that really helps that. And then we have the 7.4 3.1 provision of the UNIDROIT principles that provides 5 different factors to determine that. Why not give the arbitrator the discretion to take into account those elements to see that if there are minor breaches, it doesn't warrant determination, but some other type of remedy. So in many ways, I think this is extremely helpful. We have been talking about, and with this I finish, Madam Chair, we have been talking a lot about not only what the uses of the principles are, but what the future uses could be done. And I agree with Professor Bonnell that much can be done in this area with contributions among different law formulating agencies in the world, with arbitration centers that can provide useful information, bar association committees that deal with international commercial law also may be helpful to do that. But I also think that among these different issues, these different things that can be done, just in order not to fall in a very misleading complacency about how successful is the UNIDROIT principles, that nobody doubts about it, why not thinking about one of the grave problems of the UNIDROIT principles that they suffer is that people don't know about them. And we heard negotiators and seasoned drafters of contracts yesterday saying that on the one hand, they had the obligation to defend their clients and they will put all the one-sided provisions they can get away with. But on the other hand, they also said that the other party's rejection to use their principles is, we don't know it. And it perhaps falls upon us, those who have the opportunity to teach in any part of the world about contract law, to rely on those principles, to tell them there are standards that can be used as a comparative, as a background law, to compare and contrast the standards you have in your domestic law. That in itself is very useful. Thank you, Madam Chair. Thank you.
Thank you very much. I didn't have to bring out the alligator. Thank you, Alejandro. This is a perfect, so what Rupert Reece will now touch upon will be, I think, a good segue to this more general presentation that you have given on all the possible ways the UNIDROIT principles can and perhaps from what you say should be used by domestic courts or in domestic courts. We have now Rupert Reece, who is a partner at Gilles Loiret Noyel based in London, and he is an English barrister and at the same time an avocat au barreau de Paris. And he has a very long-standing experience acting as counsel and arbitrator. And what he will do now is he will speak about the UNIDROIT principles and English courts. So it's not an oxymoron, perhaps. You have the floor, Rupert. Thank you.
Thank you, Anna. Good afternoon, everyone. It's an honor and a pleasure to be with you today. Well, I was fascinated to dive into this subject, which I confess I did not know perfectly before diving into it. And I was surprised as well. Professor Garro, perhaps you would be surprised as well to hear when we say that people don't know about the UNIDROIT. The English courts do know about UPICC. And while they do not have a long history of applying UPICC, they have quite recently been used in quite radical ways to, as a reference point in particular, to support evolutions of English law. And it's an evolution that I hope those in this room will find encouraging. So let's start with the ways in which UPICC can come before an English court. Is that working? Yes. Well, most easily, perhaps, UPICC can be referred to by the parties in their contract, which contains an arbitration agreement. And under the Arbitration Act, Section 46, the arbitrators will decide the dispute if the parties so agree in accordance with such other considerations as are agreed by them or determined by the tribunal. That's an invitation if the parties choose to refer to UPICC. It may also come before the court if the parties have referred to UPICC in their contract, even if the contract is governed by English law and with English courts as a choice of jurisdiction, the court then will give effect to UPIC as being incorporated in the contract by reference. And as I said, and I'll talk most about this this afternoon, UPIC has been used recently as a reference point, a sort of comparative analysis by the English courts in developing English law. So first of all, some examples of a recent case in 2022 where the court confirmed that a choice of law may include a non-national set of legal principles, such as the 1994, they could have referred to the 2016, perhaps, UPIC, or other principles such as lex mercatoria. Here's an example of a contract again, which had an arbitration clause in it, where the parties had agreed that the agreement shall be governed by the internal laws of the United Kingdom, which is perhaps pathological in itself, because that's at least two different jurisdictions contained in the United Kingdom, and interpreted in accordance with the UNIDROIT principles, UPIC, again, 1994, but that was at the time of signature of the contract, of course. And most recently, and most interestingly, in the case of Kebabji against Kaut Food, which is a case which has become quite famous in relation to the governing law of an arbitration agreement, and actually resulted in inconsistent decisions in the UK Supreme Court and in the Paris, courts in Paris, right up to the Cour de Cassation, relating to the possibility of extending an arbitration agreement and a contract to a third party who hadn't actually signed the contract, but was alleged to have become a party to that contract by its conduct. Here, the contract was governed by English law, in a clause which I haven't reproduced. But then it is said that the arbitrators shall also apply principles of law generally recognized in international transactions. Sorry. Who said this? This is a judgment in the Supreme Court. So this is the Supreme Court going through the facts of the case. And this is a citation from the contract. So the contract provides the arbitrator shall also apply principles of law generally recognized in international transactions. And then the Supreme Court says in the paragraph at the bottom, the parties are agreed and we are content to accept that the reference to principles of law generally recognized in international transactions is to be understood as a reference to the UNIDROIT principles of international commercial contracts, and then goes on to describe how the UPIC has been produced. And I think we can see there, that's the encouraging statement. The UK Supreme Court knows exactly where UNIDROIT is coming from, and we'll see goes on to treat UPIC with utmost respect. So I think you talked yesterday, there are many ways in which UPIC is similar to English law, and there are several ways in which UPIC is maybe said to be inconsistent with English law. I've listed a few of them there. I won't go through those, but let's look at the ways in which sometimes the courts have used UPIC as a reference point. So recently in a case about penalties, there was the English courts have recently allowed the law on penalties to evolve and have changed the test under which a liquidated damages clause can be found to be valid or not under English law. And there was a debate at one point in the court as to whether there should be a judicial control of liquidated damages clauses at all. And the court said, of course there is, we do it, and many other systems do it. And it is included in influential attempts to codify the law of contracts internationally, including the UNIDROIT principles of international commercial contracts, for example. That's an example of where the UPIC was cited with approval. In some other cases, it's cited with as a means of distinguishing English law from other systems. For example, in the case of Chartbrook against Persimmon Homes, where the court was looking at things that could be taken into account in the interpretation of contracts. And the question was whether whether previous negotiations or pre-contractual negotiations could be taken into account as evidence of the parties' intentions when entering into the contract. There, the court looked at UPICC 1994 and 2004 versions, but the court then found that these instruments reflect the French philosophy of contractual interpretation, which is altogether different from that of English law. However, this is the most interesting evolution, I think, as the evolution in relation to the validity or not of no oral modification clauses or formalities of variation clauses under English law. There have been two recent decisions, one Rock Advertising in 2018 and another Kebabji, which we looked at a little bit earlier in 2021. And in both cases, the Supreme Court has referred to and compared English law with UPICC. Now, before Rock Advertising, there might be some debate on this, but it's generally, I think it's correct, that the law, English law in relation to no oral modification clauses was that even if there is a clause in the contract that says, for example, that this agreement may only be amended by an agreement signed by both parties in writing. So even if there is that clause, that would not prevent the parties later varying the contract by an oral modification if the court was able to conclude at that time that that was their intention and if that variation was supported by consideration. And it's quite an interesting, even philosophical debate. Should the court give effect to the parties' real intention as of today, as of the moment of the variation, or should it give effect to the intention of the parties as evidenced in their original contract to only allow variations according to a certain form? And the Court of Appeal in Globe Motors summarized the law as it was at that time, which was that because parties can make contracts both in writing or orally, then if the parties choose to change a contract, even if it was written in the past, if they choose to change it by an oral modification, then the court should give effect to that. And they made an analogy to a principle that is important to English lawyers about the position of Parliament, which is said not to be able to bind its successors. If Parliament passes a law, a subsequent Parliament is always free to repeal that law. In the same way, parties, if they agree something, they're always free to agree something else. However, if there is a clause, a no oral modification clause in the contract, that's nevertheless a significant evidentiary factor that could be taken into account later on when the courts are trying to decide whether or not the parties really did intend to make an oral modification, or if it was just an accident, or if it was not actually their intention to change. Am I at 5 minutes yet? Thank you. So here, Rock Advertising, a case which went all the way up to the Supreme Court. It was a written contract which contained a no oral modification clause. All variations to this license must be agreed, set out in writing and signed on behalf of both parties before they take effect. Rock fell behind and proposed to revise with lease payments, proposed to revise schedule. That was discussed and allegedly agreed in a telephone conversation, and Rock actually made a payment, but then the licensor went back on it 2 days later, and the question was, should it be allowed to go back? And there, in the Supreme Court, Lord Sumption decided that, contrary to the previously decided cases, in his opinion, the law should and does give effect to a contractual provision requiring specified formalities to be observed for a variation. And he did so starting from the point of party autonomy, so contrary to the view that I just expressed, he said it would be an offence to party autonomy if we did not give effect to the no oral modification clause. And he said, look, there are many international systems which do that. For example, the UNIDROIT principles of international commercial contracts. And he said in there, it is recognized that contracts can be made orally or in writing in Article 1.2. And yet in 2.1.18, a contract in writing which contains a clause requiring any modification or termination by agreement to be in a particular form may not be otherwise modified or terminated. So he says these codes show that there's no conceptual problem with that, and he found that that's what English law allowed. Now, it may be thought that he went too far after this, because he said the only way out under English law is estoppel. So if a party has agreed to an oral variation, for example, they may not be able to rely on that if they are estopped by various doctrines of estoppel under English law from insisting on that variation. And he said, he didn't go into all the details of estoppel, but he said this is not the place to do so. But there has to be something more than just the oral promise itself, or just the change in the agreement, or just the conduct. And that's where I think that he goes further than the let out or the safeguards that we saw at the last paragraph of 2.1.18 under the UNIDROIT principles. In that under the UPICC, there must be conduct, but there's no need for some of the conditions that exist under English law for estoppel, which would include an express representation. There's no need under UPICC for reliance to a party's detriment. Whereas under English law of estoppel, the party would have to show that they have relied to their detriment. And importantly, under UPICC, there's no need for an express representation. These are the conditions proposed by assumption. Express representation that the variation is valid, notwithstanding its informality. It's going further than just it requires in order to move away from the no oral modification clause. Assumption requires something that goes further than just the conduct that is required by UPICC. And in the case of Kebabji, I can finish on this slide, the court relies on ROC. The Supreme Court again repeats the conditions imposed by assumption. And in this case, as we saw here, there was an express provision in the contract that required the arbitrators to take account of the what was agreed to be the UNIDROIT principles. And here the court says, and this may be one step back, we've had one step forward, maybe it's one step back. For reasons already explained, the UNIDROIT principles can only be relied upon to interpret or supplement English law, not to contradict it. I'd like to open that up for discussion. What does supplement mean if it doesn't mean change in some way? In the present case, the claimant is seeking to rely on the UNIDROIT principles to contradict both the no oral modification clauses and the minimum requirements set out in ROC advertising, which must in English law be satisfied if a party is to be precluded by its conduct from relying such clauses. Such reliance on the UNIDROIT principles is contractually impermissible. So I think what we see, just to conclude, is the English court recognizing UNIDROIT, using it as a useful reference point, then going, I think, beyond the UPICC principles, I think in a way that risks creating injustice. But in any event, I would invite both UNIDROIT and the English court to revisit this rule on no oral modification clauses and the way they fetter party autonomy at any given time. Thank you very much.
Thank you very much, Rupert, for this excursus on the application or the mention, at least, of the UNIDROIT principles in English courts and by English courts, which, as you say in itself is evidence of the fact that they are out there and well known, and at least they are something one has to reckon with if you want to modify something in your legal system or develop a specific area. So now we have, I think, sufficient time for discussion. We had planned one specific contribution in the Q&A, which, however, will not materialize, from Professor Giacomo Rojas Elgueta, who is in Hong Kong and is not has no possibility to, even if the system now works, I would like to let you know that the system now works, and so everyone online can intervene if they want to pose questions, or much better than before. So I would like to, first of all, thank the panelists, but before thanking them more thoroughly, to open up the floor for questions or comments. I already see Professor Moreno's hand up. Jose?
Thank you, Anna. Well, I want to congratulate and also make a comment. I want to congratulate Professor Vial not only for her excellent presentation, but also for the Chilean draft of private international law. I've heard many prestigious scholars of the region saying that if approved, that would be the best private international law in Latin America. So congratulations for that draft. And I just want to compliment a little bit because the Mexico Convention, then the OAS continued working. The Inter-American Juridical Committee analyzed if it would be feasible to modify the Mexico Convention to make some adjustments, specifically regarding minor interpretative issues. One of them, the one raised by you on the absence of choice. And then the final decision was to move forward with a guide, not to pursue more ratifications of the Mexico Convention, but to encourage national legislators to modernize their national laws. That would be simpler, and that is why the OAS prepared the guide that was approved in 2019. I understand that the Chilean draft was already finished by that time. It's excellent anyways. But something very relevant is that that guide advocates in favor of Friedrich Junger's interpretation of the convention, and it guides national legislators to do that, to follow that line. By the way, Professor Junger was born in Germany, so this is a truly transnational convention. He was there on behalf of the US, but he was originally born in Germany. This 2019 draft was endorsed by UNIDROIT, expressly by the Governing Council. It was welcomed by the Hague Conference of Private International Law. It is, as I understand, the only regional soft law instrument cited in the tripartite legal guide of UNCITRAL, UNIDROIT, and the Hague Conference. So it has really something like a strong standing internationally. And that interpretation is particularly relevant because the instrument was approved by the General Assembly of the OS that approves conventions. So it has the approval of the Assembly, and I think that's a very relevant point. And I am aware that this instrument, as well as the Mexico Convention, have influenced the final stages of the Uruguayan draft, because Eduardo Florio, who was a student of mine at Heidelberg in Chile, he was the advisor of Senator Carrera, who was the one who finally took the project. It was there sleeping in Congress for many years. And then, yeah, they introduced these final adjustments to make the instrument amicable to soft law, particularly for the reception eventually of the UNIDROIT principles. Also, it's relevant that both the Mexico Convention and the OAS Guide are cited in a bill presented to the Brazilian Congress. It's currently in the Brazilian Congress, and Professors Nadia Araújo and Claudia Lima Marquez are some of the drafters of the law. And the instrument also cites these regional developments. As these instruments also were taken into account by drafts prepared in Colombia, Guatemala, Professor Mendoza, Professor Madrid, and Jose Luis Marin in Colombia. There are 2 drafts. And just one final comment regarding Professor Garro's excellent, fantastic presentation. It is, of course, a task of professors, but there's also a discussion that the organizations must not only produce instruments, but there's an equal important task afterwards of dissemination. And I think UNIDROIT has been doing a very good job in disseminating this work. And it's perhaps a challenge of, that we should be analyzing how to do that more and with a higher impact. So that's homework for the future.
Thank you, Jose. Before giving the floor to Maria Ignacia, if you want to apply, and to Alejandro, who also had an additional question, I will comment. Thank you for raising an issue which goes actually, I think, beyond the anniversary of the UNIDROIT principles in terms of how uniform law develops, because we see hard law conventions being transformed and being, used even by express will of the some, at least, of the countries involved, or at least representatives in an intergovernmental organization, becoming soft law instruments, so model law, so modifying and we have seen this even without the intermediary of such a resolution or such a decision or such an instrument as the one you have drafted for other instruments, that starting with hard law, you then use that instrument not as a treaty to be ratified by countries, but increasingly as a set of model provisions that might be integrated into legislation and still have an harmonizing effect. But this was completely beside the scope of this conference. Still, I could not resist because it was very interesting. So allow me to give the floor to Maria Ignacia, if you.
Thank you. Well, first of all, thank you for everything you have said, because you have completed information in a fantastic way. And the other thing is that I would like to raise your attention that Janet Trammell is also here, who has been working a lot in the guide, and she has been very important in this. The work of the Inter-American Juridical Committee and the OAS, and she is very knowledgeable about, so she can teach everything about it. But then another thing which I think is very important is the work you've done, you personally have done, because this idea of becoming at the same time a member of the CGI and then the Hague and the UNIDROIT has been a fantastic link between the organizations, and I think it has enriched the work of the CGI, the Inter-American Committee, Juridical Committee, and also the Hague, your own country's private international law. So I think what I have to say is thank you very much.
Maria Ignacia. Alejandro?
Yes, I want to take the opportunity that Professor Vial Undurraga has been so clear about the Mexican Convention and how interesting the antecedents of the convention was. But I noticed that you mentioned Articles 9 and 10 of the convention, and much of the opinions that you see of the very scholars that are against the idea of applying a non-state law, they refer to Article 7 that specifically says law. And the Mexican Convention really used the Rome I regulation as a very reliable source of inspiration. So I think that, I guess, this scholars take out from this Article 7 that clearly says that the parties have the right to choose the law applicable to the contract, that excludes the other one. There could be other reasons, and that's why I want to ask you, whether do you expect in the Chilean Congress, and I hope that it will take up the project very, very soon, but do you hope in the Chilean Congress opposition to the idea to the party's freedom to choose the applicable law? Because I want to know, this audience coming from different parts of the world may want to know about what may be the arguments against in Latin America to that. It has been a position in the 19th century, but not seems to be any longer, as you show us in the new ones. So if you can elaborate on that, I appreciate it.
Thank you. Well, first of all, I have to give a sort of little introduction, but because we don't have in Chile a private international law act, we drafted a draft bill, and one of the most important things we wanted is to clarify the position of our law in respect of party autonomy. And party autonomy has been accepted in Chilean law, in commercial law, for many years now, but there are some doubts about civil contracts. So that's why courts have not been very clear in accepting party autonomy. Sometimes they consider and construe one provision in the civil code as a mandatory provision ordering the application of Chilean substantive law, and then they reject the application of a foreign law, the chosen foreign law, to some types of contracts. I don't think, Alejandro, now there's going to be any problem in the Chilean parliament, because I think there's a huge trend between academics and practitioners to press the courts and to convince the courts to uphold choice of law clauses. And the other thing which I didn't mention is that we have been increasingly using the UPICC as a way of supplementing Chilean substantive law, and also as the way of supplementing the Vienna Convention, because we have been using the PIC for instance, for clarifying what is reasonable, which is the reasonable behavior of the parties, and things which are not so clear in the Vienna Convention. And this has been mainly the work of academics. That we were discussing yesterday about some academics. They have published several books, and they have given legal reports to courts, and that has been very good because they have made the UPICC very well known within Chilean courts. And now it's increasingly there's an increasing trend to have recourse to the UPICC in international litigation in Chile, and also in arbitration. Thank you.
Thank you very much. Christina.
So, Mr. Reece, I was very interested in hearing about the English court references to UNIDROIT principles. And from the little I've read about it, I was fascinated by how respectfully the court addresses the UNIDROIT principles. And then sometimes say they don't correspond to English law, but still very respectful. So I have two questions. The first is, and this may be a bit hard for you to answer, but is it your impression that the same respectful attitude is used by the courts towards CSG? And the second question is, this unawareness of the UNIDROIT principles that we've heard about throughout these 2 days, do you think that when the Supreme Court makes these respectful references to the UNIDROIT principles, that they will become known to ordinary lawyers in the UK?
Thank you. Interesting questions. The quotes that I have picked out from the court cases which refer to UNIDROIT do also actually, either in the paragraph below or above, also refer to the CISG often. So in particular in rock advertising, the Supreme Court referred to both. So that they are both respected, certainly respected. You never, well, you certainly don't read anything disrespectful at all. There was the case that I flashed up that showed them being qualified as French. But I think that, again, that was a way of distinction, not disrespect. Then will they become known to general practitioners? Well, very often, of course, a court responds to the case that is put to them by practitioners. So these submissions will have been made by practitioners. And I know in the Kebabji case, although I wasn't involved, it's certainly something that the practitioners put forward. So the principles are known to certainly international practitioners. And I'm afraid I wasn't here yesterday, but I'm sure when you were talking about UNIDROIT in arbitration, it's very often a reflex that even an English lawyer will be to go and have a look at how a particular provision may have been interpreted under the UNIDROIT principles. So they are becoming known. They're obviously not universally known and practiced by the everyday practitioner on everyday English disputes, but they are known, and the fact that they are referred to in reported cases will contribute to that.
Thank you very much, Rupert, Nisreen, and then Helena.
It's a quick question to Professor Reece. I dealt with English law and CISG 25 years ago when I were preparing my PhD thesis. And I'd like to hear your comment on the position of the UK towards not ratifying the CISG. These days, I just want to compare the reasons I wrote in my thesis to the reason now. Are they still the same or not? I'm
really sorry. I couldn't give you a definite reason on why the UK has not yet become a member of the CISG. I mean, it does. I guess the UK does consider at the moment that we have a core of law that is sufficient, and that it's not necessary to adhere to the CISG. I've heard the same as you.
You, Helmut.
Well, I would want to ask you something, and I hope I didn't miss it in your words already. You mentioned the English case where they confirmed that in an arbitration proceeding, you could choose the PICC as the governing law, and the choice of law would actually have the effects of a choice of law. And then you were mentioning later on many cases where the English courts have referred to the PICC without them being the applicable law. And there was one case where you have said that English law was chosen, but the PICC would be the guide for interpreting the contract. Has this also been a case of arbitration? And would you dare to say anything about whether a state court would accept a choice of law in favor of the PICC under the conflict rules in England that have been Rome Convention, I guess, and not probably anymore?
No, that is still the law. The case that I referred to was Kebabji against Cowart, and that was an arbitration case. And the parties there provided that the contract would be governed by English law, and that the arbitrators would also give effect to principles of international law, which were then agreed to mean UNIDROIT principles. So that was an arbitration case. Then in relation to a case before the English court, if it was not going to arbitration, there I think the principle still remains that the court would choose the law that is applicable to the contract according to English principles of conflicts of laws, which are still applying the Rome I regulation even after Brexit. And the court would regard the contract as being governed by English law, but incorporating UPICC by reference. So there's been no change there.
Thank you. Roy.
My thanks to all three speakers for some wonderful presentations. I just wanted to offer a response to the question as to why the UK has not adopted CISC. And I think the reason may be that the UK never adopts any. First of all, it's always reluctant. They do a lot of work towards the making of conventions. When it comes to ratifying, they tend to walk away. And they don't normally ratify unless there's strong pressure from the relevant industries. And in the case of CISC, the problem is that it doesn't work very well for documentary sales. And the commodity traders, therefore, will not want CISC to be adopted because it really doesn't fit. And I think they're right about that. It's not actually very well adapted to documentary sales. FOB contracts, CIF contracts, that sort of thing. And there may be other reasons, but I suspect that that is one of them. And it's difficult to answer that because you have to get the commodity traders on side.
Thank you, Roy. So any final comments by the panelists? Nobody online. So if this is the case, then I would like to thank, first of all, the wonderful panelists. Thank you all for your perseverance. And now we have a short coffee break. Please be here on time at 4 because we have the final panel where we will talk about the future. So we need all of you to chime in this important discussion. And thank you again for your patience until now.